Do we need a few minutes?
We do have Mr. Richard that is on Zoom. He's listed as the authorized representative of Devontae.
Welcome back to the courtroom, folks, and buckle up, because today's case is a sovereign citizen masterclass in self-destruction. Our defendant, Devontae Richard, refuses to call himself a defendant at all. Instead, he insists he's merely an authorized representative of some account, as if renaming himself can erase legal obligations. The judge, however, is having none of it. What begins as a simple hearing to confirm a court-ordered evaluation spirals into a spectacle of denial, memory lapses, and sovereign citizen script reading. Here's what makes this case so fascinating. Richard was present at the last hearing where the evaluation date was set. He heard it, he acknowledged it, and now he pretends he knows nothing. Throughout this hearing, we'll see him demand impossible proofs, argue definitions, and even try to cross-examine the court as though this were a trial. But the judge is razor-sharp, constantly steering him back to reality. Stick with me, because by the end, Richard's sovereign magic words won't save him, and the fallout will be 10 times worse.
And video, so I know that you are hearing. Okay, thank you. The case that I believe I saw recently, there was a eval set up and they were unable to reach him to participate in that evaluation.
That's my understanding, Your Honor. I saw that as well. I think the last time we were in court, counsel indicated that the meeting had been set up to do the evaluation and the date was discussed. And it looks like Mr. Richard did not appear for that.
And for the record, Sean Parent for Mr. Richard. Yes, unfortunately, that appears to be the case. I'm not sure why Mr. Richard didn't appear at the evaluation.
So, Mr. Richard, we've been waiting for you to talk to one of the doctors, and we've been setting this case over for that to happen. When you were here on April 8th, we discussed that you were scheduled for that appointment on April 24th. So I know that you were aware that they had you calendared. Mr. Richard, why didn't you show up for that appointment?
Well, that was an assumption. I wasn't aware of anything.
Well, you were at the hearing when we talked about it, so.
One of the oldest sovereign citizen tactics, claiming ignorance despite direct evidence to the contrary. The judge clearly reminds Richard that he was present at the April 8th hearing, where the April 24th evaluation was scheduled. But instead of acknowledging this, he pretends he needs signed confirmation. This is a deliberate game. Sovereign citizens often attempt to create confusion by demanding paperwork or pretending instructions weren't valid unless notarized, signed, or mailed in triplicate. The problem? Courts don't operate on assumptions and presumptions. They operate on records. And the record shows Richard.
April.
Was there anything signed for confirmation?
Your attorney has been working to get that set up. So.
Well, I haven't talked to anybody.
Mr. Parent, have you been in contact with Mr. Richard?
Looks like my office, we tried to reach him to make sure that he appeared at the evaluation, but we are unsuccessful in reaching him.
Do you have proof of that?
Yes, I have my colleague's notes that we tried to get a hold of you.
And what was the number?
So, Mr. Richard, we have the phone number that ends in 1752.
I'm talking about the number you supposedly contacted the defendant on.
Yeah, you're the defendant, and it's the phone number that ends in 1752.
No, that's an assumption and presumption. I'm not nobody's defendant.
Richard flips the conversation from his missed appointment to nitpicking the phone number his lawyer used to call him. This is a clever, but transparent, diversion. Instead of addressing why he didn't show, he demands proof of contact. Then comes the sovereign twist. He says he's not the defendant at all, but merely the authorized representative. This language comes straight out of the sovereign citizen playbook, where they try to separate their flesh and blood person from a fictitious legal entity. Judges don't buy it, and neither should we. It's a fantasy, but Richard believes he's
Participate out of custody. The court may have to set bail and have you placed in custody to get this evaluation accomplished. So when you are informed of the appointment and then you choose not to appear, the court interprets that as a willful violation.
Under what law are you saying that I could, what charges, what are the charges?
We've gone over that. You have been told that you are charged with driving while license suspended and driving without an ignition interlock device. So I understand you disagree, but at this
what was the
point,
date?
we need
I
to,
don't disagree with none of the facts. I said, what was the date?
the date of the driving. Is that what you're asking?
Well, I don't drive, so I'm trying to figure out the date you have on file.
June 4th, 2022, Your Honor, is the charge date.
Thank you.
Okay, and have I been charged with anything?
Yes.
And what is it? What are the charges?
As the court just read aloud, driving while license suspended and driving without a functioning ignition interlock.
And is there a witness that you can bring?
Interrupts with, under what law? A textbook sovereign question. The judge calmly lists his charges: driving with a suspended license and driving without an ignition interlock. His response: I don't drive. This is where sovereign citizen logic goes into overdrive. They believe that if they deny the act itself, the charges disappear. But courts deal with evidence, not self-declarations. What's even more telling is how Richard tries to rush the process, asking for a witness as if today were trial. He's either deliberately stalling or he genuinely doesn't understand the difference between a pre-trial hearing and a trial. Either way.
Yeah, but do you have a witness?
Yes, the city has witnesses. We have the officer that will be testifying.
The officer. Okay, well, can you read the police ticket on the record?
We're not having a trial today. We're trying to figure out whether or not you are competent and able to proceed in this matter, and that requires that you speak to a doctor. But that is what we're trying to accomplish. And Mr. Richard, if you refuse.
Can you explain to me? I don't understand. So can you explain to me how
We've
this works?
explained this to you previously. So what I'm going to ask you is whether or not you are going to comply with meeting the doctor out of jail, or does the court need to set bail and have you booked into custody so they can talk to you there? That's not what I'm wanting to do. I would like you to cooperate and have this case proceed with you out of custody.
Well, I need some type of contract to obtain to whatever you're asking, because I have questions and you're not answering them.
Your Honor, at this point, I think given the track record of Mr. Richard and his unwillingness to comply, the city is going to be asking that the court set bail and remand him on that bail to have the evaluation done in custody.
Mr. Richard, can you assure the court that you will come to an out of custody evaluation?
I will agree to anything if you guys can tell me the nature and cause of this action.
Where Richard really digs in. He demands a copy of the ticket read aloud and insists he won't agree to anything unless the nature and cause of the action is explained to his satisfaction. This nature and cause mantra is a sovereign obsession. They repeat it like a spell, believing it voids the court's jurisdiction. The prosecutor sees exactly where this is going and asks for bail. Think about that. What could have been handled outside of custody is now escalating to the point where jail time is on the table. All because Richard refuses to engage.
I hear your question. What are you asking?
I need to know the nature and cause of this action. I need to know that before we can move forward.
Yeah, I believe that the court has told you that you're being charged with driving a license suspended in the 3rd degree and operating a motor vehicle without an ignition interlock device.
Okay, well, I have a question for the judge.
What's that,
Hello?
Mr. Richard?
Hello?
Mr. Richard?
Hello? Or can you hear me?
Yes, I can hear you. You should sit down, and then instead of having me facing you at the clouds, you should participate in this hearing. Thank you. So every time we have a hearing, you ask these same questions, and we've explained to you that you're facing criminal charges and that we need to have the doctor speak to you. And so right now, your option is whether or not, as your attorney said, you can agree to meet with the doctors and stay out of jail to do that, or the court will have to remand you into custody so that they can
So
talk to you
basically,
while
you're
you're
telling
in
me you're
jail.
refusing to answer me. You're refusing to answer any questions? That's what you're saying? Because I just have questions.
We've answered your questions. We're going to proceed at this point. I'm going to.
I didn't even answer. I didn't even ask the question. So how did you answer it? That's what I'm saying. Are you refusing to answer the questions?
What do you want to know besides what you're charged with? What was your other questions?
My other question was, did you or did you not take an oath to uphold the Constitution? Can I just get a yes or no?
That would be a yes.
So you're enforcing statutes right now, and so you're totally going against your oath. So I'm trying to figure out what authority do you have to tell me to do anything as a public servant?
Mr. Richard, I am authorized by the revised Code of Washington to sit in this court. I'm duly appointed to be a municipal court judge. I've taken my oath. You're charged with a violation
if you
of
took
the
an oath,
RCW and the Lake
if
Forest
you took
Park
an oath,
Municipal
then why are
Code.
you why are you enforcing statutes?
The judge has been patient, maybe even too patient. Richard isn't asking questions to seek clarity. He's asking them to create a loop, forcing the court to repeat itself endlessly. Then he tries the oath trap. Did you swear to uphold the Constitution? When the judge says yes, Richard launches into the argument that statutes can't be enforced if she swore that oath. This is pure sovereign rhetoric, the belief that constitutional rights override all statutory law. What Richard ignores is the simple truth. Judges are empowered by state law and the Constitution. His argument collapses.
Bail. I'm
I
going
didn't
to
say it
set
didn't apply
bail
to me.
in this matter at
You're making
$10,000.
assumptions, ma'am. You're making assumptions, ma'am. I never said it didn't apply to me. But we both know here that the Constitution is not for me. It is for the public servants. So I don't know why you're making assumptions and presumptions. All I had was questions, and you're just going around me.
So, Mr.
Obfuscation
Parent,
is
I'm
a
going
big
to
thing
set
now.
bail at $10,000, and we're going to end this hearing, Mr. Richard. You can report to jail. You can come in, but we are trying to do this without you having to be in custody, but you are refusing to cooperate.
I didn't refuse anything. I was never put on notice, so I didn't refuse anything.
Oh,
Everything you're doing
I
right
know
now
you
is
were put
because
on
you wanna
notice
do
at
it.
our last hearing, so that's on the record. So
What's
I
on the
know that
record?
to be false, Mr. Richard. So that
So
is the status of this case.
everything that I asked you, am I wrong? Is that
Yes,
what you're saying?
yes, you're wrong. So we're
I'm
gonna
wrong.
end this and we are done on this matter. Mr. Parent, if he does reach out to you and something can be arranged for them, but right now the doctors have tried twice to contact you and you've taken a spot that would have been available to someone else. So we need to progress this matter and that bail will be set and we'll continue with an in-custody hearing date.
Richard has cornered himself. His fallback is the claim that the Constitution isn't for me, it's for public servants. That's not how it works. Constitutional protections apply to all people within U.S. jurisdiction, not just government workers. But this line exposes the real purpose of sovereign rhetoric. It's not about freedom, it's about avoiding accountability. The judge, however, has reached her limit. With endless delays, wasted court resources, and outright refusal to cooperate, she sets bail at $10,000. This is the moment Richard realizes his word games carry real-world.
And then you're held liable for everything you do from here on out.
All right, thank you, Mr. Richard.
A textbook sovereign citizen meltdown. What began as a straightforward requirement, show up for a court-ordered evaluation, spiraled into denials, semantics, and conspiracy logic. Instead of securing his freedom, Richard's antics guaranteed the opposite: $10,000 bail and the very real possibility of jail time. This case is a perfect reminder that sovereign arguments don't just fail, they backfire spectacularly. Now I want to hear from you. Do you think Richard truly believes his sovereign script, or is it all an act to dodge responsibility? Drop your thoughts in the comments. And if you found this breakdown as jaw-dropping as we did, hit that like button, share this video, and don't forget to subscribe for more epic courtroom showdowns and sovereign citizen fails.